Hi, everyone, and welcome to our webinar on defending against multi-front investigations, what to do when the FTC, Cfpb, and state attorneys general have opened parallel or joint investigations. And before we get started, I have just a couple quick administrative points to share. For those of you wondering about CLE, this webinar will provide CLE credit. We'll be sharing the code for the CLE later in the presentation. And throughout the presentation, if you have any questions, you can use the chat feature, I believe, to submit them. And if we have time at the sort of closer to the end of the hour, we will get to as many of them as we can to end the presentation. Next slide, please. Thank you. So for this webinar, I'm joined by my colleagues, Len Gordon and Alex Megaris, who you will hear you'll be hearing from both of them. Len chairs, for those of you who don't know him, Len chairs Venable's advertising and marketing group. He regularly represents companies and individuals in investigations and litigation with the FTC, state AGs, DOJ, CFPB, and others. And he represents clients in business-to-business and class action litigation involving both consumer protection and antitrust issues. He was formerly the regional director of the FTC's New York office. Alex Megaris is also a big part of the presentation, and she'll be focused. And her practice focuses on complex regulatory investigations and government enforcement matters involving state AGs, the FTC, CFPB, state regulatory agencies, and the US Congress. And she has extensive experience with consumer protection laws, such as UDAP laws, the Ftc Act, the Consumer Financial Protection Act, and the FTC's telemarketing rule, which we'll be hearing about a number of those today. And this is going to start to sound familiar, but my name is Erik Jones, and I also represent clients in investigations before congressional committees, the FTC, state AGs, the DOJ, and others. My background is I formerly served in the Illinois Attorney General's office, the Senate Commerce Committee, and earlier in my career, the House Oversight Committee. So the three of us decided to do this presentation because we are often representing clients facing not just one investigation, but usually multiple investigations at the same time. And we have all participated in webinars on the FTC or the CFPB or state AGs. But we thought it would be helpful and interesting to do one, not just on one in particular, but to talk about how all of these different agencies can interact and how this dynamic, when there are parallel or joint investigations among them, can present particular challenges and questions for our clients. And so today we're looking to walk you through that. More often than not, as many of you may know, when a state attorney general is conducting an investigation or part of a multi-state investigation, it also means the Federal Trade Commission or the Consumer Financial Protection Bureau is likely conducting an investigation as well. And in my experience, the saying that when it rains, it pours is apt for government investigations. When a client receives a civil investigative demand, also known as CID or subpoena, at the state or federal level, I expect the client to receive something similar from either the federal or state level as well, or vice versa. And when it comes to consumer protection related investigations, when you get one from a CID or a subpoena from a state AG or multiple state AGs, you're probably going to get one from either the FTC or the CFPB or potentially even both. And this kind of dynamic raises a number of questions from clients that we often have to answer. And these questions include, are the agencies and the state AGs coordinating? Are they sharing information? Do the agencies and the state AGs have the same goals or different goals? And when looking at settlement, how do we go about settling multiple investigations at the same time? Should we seek to join them if they are not collaborating already? And it also presents specific challenges. These include how to manage overlapping and or conflicting requests for information, and with competing timelines, whether to consolidate the investigations if they are separate, and the inevitable request that comes from the agencies, which is to produce all materials that have been produced to someone else investigating. So we'll discuss these and other challenges during our webinar today. Next slide, please. So our agenda, we're going to cover the following topics. At the outset, we're going to start with the authority that state AGs, the FTC, and the CFPB rely upon to conduct investigations. We thought it was important to start with what authority they're using to actually conduct the investigations. And you'll see that we discussed the fact that they all have independent authority, which is why they don't necessarily need to coordinate. They have their own. We'll discuss the concurrent authority that's out there, which is when Congress grants state AGs authority to investigate through federal statutes. Following a discussion on authority, we'll discuss a couple recent developments that are relevant to our discussion. We'll then provide a few examples of joint and parallel investigations and settlements in the context of the substantive areas we have listed here: data security and privacy, advertising, consumer finance, and antitrust. And then finally, we'll discuss the challenges and considerations for parallel investigations, as well as settlement dynamics when dealing with multiple investigations. And I'll now turn it over to Alex, who will be discussing unfair and deceptive acts and practices at the federal and state levels. Alex, over to you.
Thank you, Eric, and thank you all for joining us today. As Eric laid out when walking through our agenda, we thought it made sense to start with some fundamental background on the relevant authorities that the investigating agencies will be primarily talking about today rely on. And I'll start with the FTC. If we can go to the next slide, please. So the Federal Trade Commission has been around for over 100 years and has very broad authority. It regulates much of the U.S. economy. There are some exceptions to its jurisdiction. Notably, banks are not subject to the FTC's authority, common carriers, and there's some other exceptions. But the FTC really covers anything that deals with commerce within and also outside U.S. borders to the extent there's any connection to the United States. Its authority to act comes from multiple sources, including its organic statute, the Federal Trade Commission Act, which we'll be discussing, and some specific consumer protection statutes that Congress has passed over the last 100+ years, including some that are very sector specific, like the Gramm-Leach-Bliley Act, or some that are kind of media specific, like the Restore Online Shoppers Act, or CAN-SPAM and other statutes that regulate the way you communicate with consumers. The FTC, of course, is not just an enforcement agency. It also has the authority to issue regulations, which has become and will become increasingly important as we see the FTC really focus on its rulemaking and for reasons we'll discuss in a minute, increasingly rely on specific regulations when enforcing the law, including enforcing its authority under Section 5 of the Ftc Act, which generally prohibits unfair or deceptive acts or practices in or affecting commerce. Very broad, abstract language. Len, in a minute, we'll talk about what this means with respect to antitrust, which also comes within the FTC's mandate. But regarding consumer protection, which when I think of that, thinking interactions with consumers, the FTC historically relied on Section 5, its UDAP authority, to pursue companies that were engaged in deceptive acts and practices. What that means has been developed over time through case law, court decisions, and then the FTC issuing guidelines and statements, kind of concretizing what has been fleshed out in cases. And so UDAP case law has evolved over the years. That said, there are pretty laid out standards for defining those two concepts. But historically, the FTC relied on Section 5 and its UDAP authority to bring enforcement actions against companies. And importantly, with respect to its remedies, which is something you need to always think about, it relied on Section 13B of the Ftc Act, which it gives the FTC authority to bring lawsuits in federal court against defendants that it believes are violating or about to violate the Ftc Act, including its unfair or deceptive acts and practices. 13B says that the FTC can bring a lawsuit to enjoin any practice it may it deems to be a UDAP, and may seek permanent injunction to prevent such an act from happening. And for decades, the FTC took its position that this provision of the Ftc Act 13B allowed it to also obtain equitable monetary relief from defendants, primarily in the form of restitution. But and many courts for a long time, we're talking about dozens, if not hundreds of cases, permitted the FTC to do just that and obtain millions, if not hundreds of millions, in equitable monetary relief from defendants. And then 1 year ago, in April of 2021, the Supreme Court of the United States, in a unanimous opinion, which is rare these days, put an end to this. So the FTC now no longer has the ability to go straight to court to get equitable monetary relief. It still can go into court and seek an injunction to stop what it believes to be an unfair or deceptive act or practice, but it can't get restitution that way. And so it has to jump through additional hoops in order to do that, which is an important tool within its tool belt. And so Section 19 is another provision of the Ftc Act that does allow the FTC to sue a defendant and seek money, but in more limited circumstances. And first, it's to enforce certain rules, the regulations, and other statutes that are more specific. And so, as I mentioned, the FTC's regulations and the regulations that it enforces are increasingly important. And second, it can also bring an administrative case before an administrative law judge. And if it wins there, it can then go to court for monetary relief. But Section 19, unlike Section 13B, requires the FTC to jump through additional hoops. Although this decision a year ago was what we believe to be a necessary course correction, the FTC had been for years taking a position that was pretty contrary to the plain language of the statute. But it has adapted very quickly in the last year to its new world, and its strategy in terms of enforcement has been primarily, although I think we'll see some additional changes to the way it pursues enforcement, but has been to pair UDAP claims with other regulatory or statutory violations where it can seek either civil penalties or monetary relief in the form of restitution. It's also, as I've mentioned, it does have some ways to get civil penalties, and it has been maximizing those authorities by pairing, first and foremost, going after companies that have already entered into consent orders. And so this is something that also the Cfpb, which we'll talk about, has been very focused on, has made a priority. So what they're referring to as recidivists, but companies that essentially have already entered into an order, if you violate that order, it's much easier for the FTC to enforce the order itself and can pursue penalties. We're also seeing the FTC do things like kind of revive older authorities that it has under the statute that it had kind of laid dormant while it was using its 13B authority. And so we're seeing the FTC being able to adapt to this new world and still have significant tools in its tool belt. Next slide, please. We'll talk about, here's the Cfpb. So the Cfpb, unlike the FTC, when its statute was written, Congress very clearly gave it the authority to pursue not just injunctive relief, but equitable monetary relief and legal damages in federal or administrative court. The Cfpb statute, the Consumer Financial Protection Act, which was part of Dodd-Frank over a decade ago, has given the Cfpb, very broad authority to pursue any company that's involved in offering consumer financial products or services. And these are directly the service providers, but also vendors to providers of consumer financial products also are directly within the Cfpb's authority. And just like the FTC, it has in its organic statute the ability to enforce its statute against what it perceives to be unfair and deceptive acts. But it also got a bonus prong, and that is it also can enforce abusive acts and practices. While we haven't seen that prong of its statute exercised too often in the just about 10 years that the Cfpb has been around, we are starting to see it using it somewhat, and we haven't seen courts really apply it yet. So the test for what's abusive is very much based on what the statute says and not on real case practices, not real cases, but we'll see that evolve over time. And then finally, the next slide, the state attorneys general also have broad powers to enforce unfair and deceptive acts and practices. Every state has a statute that we call little FTC acts that generally prohibit unfair and deceptive acts and practices in affecting commerce within the state. And the AGs have the ability to bring lawsuits direct, in court to seek equitable monetary relief and to put an end to practices that it believes are harmful to consumers. And so these three agencies, and we'll talk a little bit more about their concurrent authority, independently have significant power to bring lawsuits and enforcement actions. And with that, I think I'm turning it over to Len.
Thanks, Alex. Great job. Hope everyone's doing well. I'm going to talk a little bit about federal and state antitrust authority. Can I get the next slide, please? So the federal antitrust statutes, I'll talk about in a second. The antitrust laws are enforced at the federal level in three different ways. The Federal Trade Commission and the Department of Justice share enforcement authority. There's a clearance process. Some of the agencies have sort of established jurisdiction over certain industries or practices. Think retail, the FTC typically does, communications, the Department of Justice does. Other times there are clearance disputes which get resolved on almost like a playground level with things like rock, paper, scissors. Wish I was making that up. There's also civil enforcement. Private plaintiffs, whether they're competitors, consumers, can bring federal antitrust claims pursuant to Section 4 of the Clayton Act. And states' attorneys general can also enforce the federal antitrust laws. What are the federal antitrust laws? We'll talk about the three main laws. Section 1 of the Sherman Act makes illegal unlawful restraints of trade. Those restraints can be either per se illegal, things like price fixing, or they can be condemned under the rule of reason. Think about things like territorial restrictions, non-price restraints. You're hearing a lot right now about Section 2 of the Sherman Act, which outlaws monopolization and attempted monopolization. Government's very busy bringing claims in that area right now, as are the states and as are private plaintiffs. And then Section 7 of the Clayton Act outlaws mergers and acquisitions that reduce competition or tend to create a monopoly. And that tend to create monopoly prong of Section 7 is something that hasn't been focused on that much, but the current administration, Jonathan Cantor, who's the head of the DOJ Antitrust Division, and Lena Khan, who's the chair of the FTC, have both made quite clear that tend to create a monopoly prong has been underutilized. The test is a little squishier, and they intend to focus a lot of their enforcement on that, including in things like vertical mergers, not a merger between two companies that historically have competed, but a merger where somebody buys either a customer or a supplier. And there is a real concern by those who currently are at the agencies that these kinds of vertical mergers have led to a aggregation of economic power, which hurts consumers and competitors. And I think you're going to see much more focus on how these types of things harm potentially competitors. The FTC also has Section 5A of the FTC Act, which prohibits unfair methods of competition. It's clear that Section 5A covers conduct that would otherwise violate the Sherman or Clayton Act. It also has what's referred to as the penumbra, acts that aren't explicitly violative of either this Sherman or the Clayton Act, but are an unfair method of competition. Exactly what those are is undefined. I think you'll see the current administration trying to push the boundaries there and expand that. But the remedies they can get there are somewhat limited. DOJ investigations are triggered by pre-merger notification filings, congressional inquiries, complaints, reading the news, just as a lot of the things that trigger FTC or DOJ consumer protection inquiries can also be triggered by things that are in the Wall Street Journal. And one of the greatest ways to get the FTC's attention is to get your congressman to complain to someone at the FTC. The agency's budget comes from Congress, and they are very receptive when Congress complains. Can I get the next slide, please? Thanks. So the state authority really is in two buckets. The states can enforce the federal antitrust laws. That's clear, and they do so. The statute actually provides for that. There is no preemption, and there's also state laws. So state laws typically mirror and are read similarly to the federal substantive antitrust laws, but there are important differences. Under federal antitrust law, consumers who are indirect purchasers of a good or service generally can't sue for an overcharge. States can. Under state law, they can, and states sometimes bring those claims. Resale price maintenance, a seller dictating the price at which a good or service is resold, is subject to the rule of reason under federal antitrust law, but under state antitrust law in certain states, most notably New York, that's still presumptively illegal. So that's a big difference. Another tool that the states have is their parens patriae authority. States can act as a law enforcer and seek to enforce the law, but they can also act as parent, essentially, for their citizens and seek to recover overcharges allegedly paid by consumers in either monopolistic conduct or in a agreement and restraint of trade that resulted in some overcharges. And one of the strange dynamics, strange to my view, is that states frequently work with plaintiffs' class action firms to bring these claims. And it really can provide an interesting dynamic where you've got sometimes class action litigation, and then you've got states who are also acting as parens patriae, and you've got the federal government. So you've got really sort of 3 or 4 different enemies that you're trying to coordinate your defense with. So it can make things very tricky, and the motivations of all these actors, which we'll talk about in a little bit, can be very different. So with that, I will turn it back to Erik.
Great, thanks, Len. As you can probably see at this point, that based upon what Alex and Len have already shared, is that there's a significant amount of overlap between what the state AGs can do and what the FTC or CFPB can do. And so that can create a sort of a complicated dynamic when both are investigating. And then to make matters a bit more complicated, Congress has also granted state attorneys general authority over and over again in the consumer protection space. And so we're now going to discuss what that concurrent authority looks like. So can we go to the next slide, please? So in addition to the independent enforcement authority that we've already discussed, the state AGs have, Congress has also provided state AGs with concurrent jurisdiction under federal statutes. And as we'll discuss, for a variety of reasons, state AGs often tend to rely upon the authority that they have at the state level, as opposed to relying upon what Congress has given to them. But this isn't always the case, and it's important to walk through what Congress has done. So there are some federal statutes that provide for concurrent public enforcement of consumer protection, and it grants state AGs and sometimes state regulators the authority to enforce provisions of the law in either federal or state courts and investigate alleged violations. This authority, as I noted, is separate from a state AG's authority under state law. It is created by Congress through federal legislation signed by the president. So a few examples of these laws include, and this is by no means an exhaustive list, but a few examples include the Restore Online Shoppers Confidence Act, the Telephone Consumer Protection Act, the Fair Credit Reporting Act, and the CAN-SPAM Act as well. Now, I can share that actually I have a personal experience with one of these laws and the state AG enforcement provision that's within it. Before I worked in the Illinois Attorney General's office, when I was working in the Senate, I was part of the negotiation and the work to pass the Restore Online Shoppers Confidence Act, which is sort of known as ROSCA. And one point I wanted to share was that when the state AG authority was part of the bill and there was the debate and the negotiation occurring over the bill, there were many parts of it that were debated, and the bill was amended as it went through the process. But frankly, the state AG portion wasn't very controversial by the time we were working on this issue in the 2009, 2010 timeframe. At an earlier stage, it may have been. And I think this is particularly relevant when it comes into, some of you may be aware of the debate that's occurring about passing a national privacy law. We see the same idea. There's still proposals out there. We haven't had anything move through, but you regularly see these bills with state AG enforcement authority as part of the legislation, whether it's a bill backed by Republicans or Democrats. And it's also offered as a potential chit for preemption, which we're not going to get into all that. At this point, I just wanted to flag that state AG enforcement authority is regularly included now. Congress does it for many reasons. One idea in the past was the idea that if the federal government is sort of quote unquote resource constrained, the state AGs can pick it up and take it on. How much that has actually occurred in practice is an open question. And next slide, please. And which we'll get into in a minute. But first, I want to talk about sort of what this authority can look like. So, as I mentioned, because Congress is creating and granting the authority, it can do so however it likes. And that means that the authority is not always consistent. There are different wrinkles to what it looks like in the various statutes that have been passed. So, for example, some federal statutes, and Alex walked us through Dodd-Frank, that one grants state attorneys general and state regulators investigative authority. So, for example, Section 1042 of the Dodd-Frank Act empowers state attorneys general and regulators to investigate state charter or state licensed entities for alleged UDAP violations. And this has been used by both state AGs and state regulators. I believe New Mexico was the first state AG to use the authority, and then the New York Department of Financial Services, or NYDFS, was the first state regulator. Next, we have that certain state statutes certain statutes at the federal level grant state attorneys general and regulators enforcement authority to enforce federal law through injunctions to curb certain practices and suits on behalf of state citizens for monetary relief. An example of that is the TCPA, which allows state attorneys general to seek monetary relief on behalf of state citizens, and enjoin the conduct of alleged violators. And then finally, and this is something we're going to discuss a little bit today as well, is this notion that a federal statute requires a state AG to quote unquote seek approval from a specific federal regulator before they can take action. Rohit Chopra, the director of Cfpb, had recently discussed this very issue. But for an example of that is FCRA, which requires state attorneys general to notify the FTC or other appropriate federal regulators before taking action under the law. As you might imagine, that when there are additional hurdles for the state AGs to sort of jump through or jump over before they can take action, that decreases the likelihood that they'll use it. Other issues include whether they have a right to bring action in federal court or state court, which brings us to our next slide, which we'll discuss. Thank you. The sort of what this looks like in practice. And Alex, do you want to take this on, and then I'll jump back in?
Sure. So the concern historically has been that allowing concurrent enforcement would lead to inconsistent enforcement across states, where you have different attorneys general pursuing the statutes, the same federal statutes, but differently across state lines. And of course, you have different courts interpreting it differently, or that there would be kind of a flood of state lawsuits enforcing these federal laws. But what we've seen is it hasn't really borne out. While there has been some cases where the attorneys general asserted authority under federal law, it really been very sporadic. And I think, we can talk a lot about why that's the case. I mean, first and foremost, as we discussed earlier, states have a lot of their own authority, that they don't need to rely on federal statutes or authority to pursue what they believe is harmful conduct impacting its citizens. And they have been able to use their own authorities and state law to do so effectively. There are limited resources, more so on the states for the most part than on the federal government. And so allowing the federal agencies with their bigger budgets to pursue those priorities seems to make sense from a policy perspective and allocation of resources perspective. There's also just other pragmatic reasons, including the fact that, getting that, for example, pre-approval from or giving notice to the federal authorities is an extra administrative hurdle that the states are not necessarily equipped to do, or to ask permission, for example, to take these on. And so while there is an ability to do that, we haven't seen it. While we're focused here on the AGs, I mean, we should also note that the FTC and the CFPB have concurrent authority to enforce many statutes, including the FCRA, which Erik just mentioned, the telemarketing sales rule, which is a regulation of the FTC. And so there's a lot of concurrent authority between those two federal agencies. And what we haven't seen is, of course, them joining forces. And that's primarily because that they have entered into a memorandum of understanding that they would not do that. There's no reason to kind of duplicate efforts given resource constraints and just the limited ability to bring cases. So there is the ability, of course, for them to do so, but we haven't seen that in practice, and it's unclear if we'll see that more, although there's been some noise of that recently.
Alex, you mind if I jump back in here for a moment?
No, please.
So I did want to add, just and I agree with everything Alex has shared on sort of why we're not seeing as much of concurrent enforcement as maybe, sort of those who had advocated for this had thought would happen initially. And I will say, from my own experience in a state AG office, I think there's a few points that are relevant here. One, maybe this goes without saying, but it's worth noting that state AGs are they're more comfortable with their own state laws. And the AGs themselves are often responsible in their offices for drafting the very laws that they're enforcing. That's not something that's often discussed, but the offices have much larger, even though maybe they aren't as large as a federal agency, the offices themselves have a lot more lawyers than, say, a state legislature would. And so the offices themselves tend to play significant roles in drafting their own laws. And whether that's updating their state UDAP laws, adding data security and privacy, whatever it is. So that's something that I think is worth noting. And then secondly, the state AGs are dealing with, like a lot of government, are dealing with strained resources, and they have an exceptionally large docket of investigations. And so if the priority is going to be, if they have to pick between enforcing a federal law or using their own state authority to go do something, more often than not, you're going to see them use their own state authority. And then finally, some of these laws, if they require a state AG's office to go to federal court to enforce, as opposed to their own state courts, that's another deterrent as well, because they know their state courts well, and it just makes it that much more complicated. It's sort of another hurdle that they don't want to have to deal with. So, but with all that said, I should note that, I mean, concurrent enforcement does happen. It's just there are reasons why it's not happening as frequently as I think those who've advocated for this years ago may have initially thought. And with that, I will turn this over to Len for the next slide to discuss some recent developments.
Thank you. Can we get the next slide? So we've talked a little bit about this, but it's worth going over some of these. Rohit Chopra, who is the CFPB director, and Lena Khan, who is the chair of the FTC, are both very vigorous advocates for very aggressive enforcement, both on competition issues and on consumer protection issues. And there is a lot that they want to do. And a lot of what they want to do is going after really large companies, and we'll talk about that on the antitrust side. But I mean, Director Chopra has sent investigative CIDs to all the big platforms to think about competition issues, not something that you would normally think about as a CFPB issue. And I think because the CFPB is spending so much energy focused on some of these huge companies and expecting fights from some of these huge companies, my sense is his plan is to have perhaps the states come in behind the CFPB and focus on some of the smaller targets that the CFPB may not have all the resources it needs to go after those smaller targets. So I think when he's urging the states to come in and enforce federal financial consumer protection laws, I think some of that is a recognition that given the really aggressive agenda that he is setting for the agency, they are resource constrained. Now, obviously, as Erik mentioned, the states are also resource constrained because in addition to doing sort of enforcement, bringing cases, a large part of the resources of many of the state attorneys general are tied up in claim mediation, individual consumer complaints that the states try to work through and get a response from companies and get people their money back on a one-by-one basis. The CFPB and the FTC don't do that, but that's a large part of what the states do. So I'm fairly certain that Chopra has this master plan. Whether it actually comes to fruition, we'll see. And as Erik mentioned, the states have a preference for their own courts and for their own statutes with good reason. But we'll see. On the FTC side, as Alex mentioned earlier, the FTC lost its ability to get equitable monetary relief from federal district courts. There's legislation's been introduced in both houses of Congress, but so far hasn't gone anywhere. But the FTC has publicly stated, and we've seen in action, that they have been partnering more with state AGs to try and use the remedial authority available to state AGs under state law and some of the specific federal laws that, where there's concurrent enforcement to piggyback on that enforcement authority. And I think you'll see states like New York and California where there's good jurisprudence that the remedial authority for those states, if a company is headquartered in one of those states, it is nationwide. And so I think you'll see a lot of that. We've seen some of that, and I think you're going to continue to see that at least until the FTC's remedial authority is fixed by Congress, if that ever happens. And some of those will maybe multi-state actions, but I think a lot of times you're going to see, the big states partnering with the FTC. We've seen a fair amount of that already. And with that, let me turn it back to Erik. Thank you.
Great, thanks. And you know what, I will go ahead and share the CLE code. In prior webinars, I've neglected to do that and then I'd have to be reminded. So I want to make sure we do that. I've been thinking about it the whole time. It's Protection 2022. That's Protection 2022, all lowercase for protection. And I'm not going to spell it because I trust that all of you on the phone or on the webinar can do that. So now we're going to jump into some examples of parallel and joint investigations and settlements, because I think we all thought that just showing what these have looked like in the past is probably helpful for those who are considered sort of thinking about what this could look like in the future. So we divided up into a few different substantive areas. I'm going to take the first one, which is data privacy and security. So, in my practice representing clients dealing with data breaches, and that's more often than not, that's what, that's not always that, but that really is what frequently triggers a FTC or a state AG investigation into data security. And typically these investigations start out as what I would call parallel investigations. They aren't coordinating. The FTC is not calling the state AGs to say, "Are you going to do this?" They just will open their own separate investigations. And when it comes to data security, this is for a few reasons, but perhaps most importantly, it's that the FTC and state AGs each have strong authority here under the prohibition against unfair and deceptive practices. And then additionally, at the state level, many state requirements for quote unquote reasonable data security for certain types of consumer data. And then in addition to that, As many of you may know, you've probably received these notifications yourselves, but the state AGs enforce the state data breach notification laws. Every state has one now, and that's entirely at the state level. And so the state AGs have their own incentives to investigate and own reasons to do so. But at the same time, just because they start out separately, that does not mean that it will not end in a global joint settlement where a client, an entity will decide to settle everything at one time. An example of this, and this is just an example, there are others that are out there, but one example is the Equifax settlement from its data breach that was with the FTC, the CFPB, and 50 states, US states and territories over allegations stemming from the 2017 data breach. It is worth noting that even in those cases, you still can have outliers. And here we have Indiana and Massachusetts that did their own individual settlements. And we'll get into this as we discuss some of the sort of the challenges and sort of considerations to think about with settlement. But there are times when it makes sense to try to put everything together, and there are times when it makes sense to keep everything separate. And to that end, we also included a couple examples on data security and privacy, still on the data breach front, related to Target and Home Depot, where they went ahead and settled with the state AGs, and there was no FTC settlement. And so these can take various paths, and it really depends upon the circumstances of those involved and sort of the facts of the individual matter to determine sort of what is the best approach. And next slide, please. I think Len's going to discuss some examples from advertising space.
Sure. So the FTC coordinates with state AGs frequently, and we'll talk about this in a little bit. A lot of it depends on who's running the agencies and who's in the AG's office as to how much cooperation goes forward. These are a couple of examples. The All-Star case was one that Alex and I handled, and ultimately we resolved those together, separate cases, but we resolved those together over buy one, get one promotions for products that you would typically think of as seen on TV. What was interesting there is the New York AG had other investigations into other companies in that space, and those investigations also got resolved, but the FTC didn't join those. So it's a little bit random sometimes as to what agency ends up, what cases they pursue, and frequently it is dictated by resource constraints. There's another case up here in New York now that's going on where the FTC and the New York Attorney General are shoulder to shoulder. That's the Quincy Bioscience case. They make Prevagen, a cognitive supplement. And this case is really good microcosm as to how the FTC's authority has changed, because when the FTC originally brought that case, the relief would have been through Section 13B of the Ftc Act, and the state, while also a plaintiff, was probably going to ride on the FTC's ability to get that relief. When that relief evaporated as a result of the AMG decision, the remedial tools available to the New York Attorney General now are at the center of that case. So it really is an example. Earlier this year, the FTC brought a case with the Illinois Attorney General's office against Napoleon Auto regarding fees that the auto dealers were charging, particularly to minorities. And that's another case where the FTC partnered with the Illinois Attorney General in some instance to leverage the remedial tools that were available to the Illinois Attorney General that were no longer available to the FTC as a result of the AMG case. And there's a host of other cases that the FTC has brought in the last year now where they've partnered with states, and you have to think that that might not have happened but for the AMG case and the need for the FTC to piggyback on the state's authority. The FTC has been very creative in trying to find other tools to use, but in certain cases where it's just a straightforward false advertising case, they really do need to use the tools that the states have to get money back to consumers. And with that, I will flip it over to Alex.
Thank you. And so looking in the consumer finance world, just also additional examples where either the CFPB or the FTC, which both regulate consumer finance to the extent it's non-banks, or the Attorney General got together and pursued cases in different ways. So most recently, it was just last week, the CFPB and the New York Attorney General jointly sued MoneyGram for violating federal laws and regulations. If you look at the complaint, there is not a single count under state law. There's a count where the Attorney General is invoking a New York statute to enforce Regulation E, but that is a federal regulation. All the other claims fall under the Consumer Financial Protection Act or the Electronic Funds Transfer Act, which again are federal statutes. So unclear what motivation the CFPB or New York had in bringing the case. The company is not a New York company, which is often the reason you'll see a state AG partner up with a federal regulator or federal agency like the CFPB, but there is a joint lawsuit there now we have pending in federal court. Looking now years back, another case also involving New York, the FTC and the New York Attorney General filed separate lawsuits, one in federal court and one in state court on the same day, against a group of companies and their principals that provide what's called merchant cash advances to small businesses. Clearly, the investigations and the decision to bring an enforcement action was coordinated between the FTC and the New York Attorney General. And strategically, they decided to bring separate lawsuits in different court systems. There, we know that the business has settled with the FTC. It's now took a ban, meaning it doesn't participate in merchant cash advance anymore as a result of its settlement. But that's a situation where there's clearly was coordination, but the decision was to file separate lawsuits. Also looking at coordination between federal and state, where we had the FTC oftentimes, as Len mentioned, does work with the attorneys general in kind of a more looking at the industry, a specific industry or set of businesses holistically. Here, this was against student loan debt relief products, and so there was a sweep that involved both multiple states and the FTC. As Len mentioned, depending on who's in office, it makes a big difference. The attorneys general, especially, are very political beings. State AGs, I think in almost every state, are elected officials. Obviously, the heads, the CFPB or the Federal Trade Commission commissioners are appointed by the president. And so there is more of a political aspect to the appointments, but they are independent agencies. But it does make it difficult coordination if there are political differences between the AG offices and those running the federal agencies. And certainly, we talk about the consumer finance world. The CFPB has been controversial since the day it was created, and been an agency that has been criticized sharply by Republicans and Republican attorneys general as well. And so you haven't seen too much coordination between the CFPB and AGs that are led by Republicans. And with that, I think we can move to the next section of our, antitrust first.
It's okay. We can get the next slide, the antitrust slide, please. Thanks. So the states and the federal enforcers have worked together frequently on big antitrust cases and sometimes smaller antitrust cases. The case that the Justice Department brought against Microsoft years ago, which was tried in DC in front of Judge Jackson, had a state component as well. And parts of the state case lasted after the federal case because there were certain different theories that the states were pursuing there. Currently, a coalition of states is suing Google and Facebook. The FTC is suing Facebook. The Department of Justice is suing Google. Some of the theories that have been brought forward were brought forth first by the states and now are being adopted by the Justice Department against Google. When I was at the FTC, we were challenging a slew of pharmacy mergers and working closely with the New York Attorney General's office. And there were a couple of deals where the Attorney General's office insisted on a separate settlement because they wanted additional divestitures. You know, a pharmacy on this corner had to be divested according to them. And you saw an even more extreme example of that recently in the T-Mobile Sprint merger. The FCC, the Department of Justice in 5 states, initially challenged that merger, and those challenges were resolved with the FCC and the Department of Justice in those 5 states agreeing to conditions for the merger. But 14 more states continuing to challenge that merger, including California and New York. And that case actually went to an injunction hearing in front of Judge Marrero here in New York. And he ultimately found that the states had not shown that the merger was likely to reduce competition, and found that Sprint was essentially a flailing competitor and the merger was necessary to let the merged company compete against AT&T and Verizon. But that was a pretty clear example of where the federal authorities and at least some of the states viewed the merits of something quite differently. And the parties thought they had to deal with at least some states, and then they had to litigate against others. And that's obviously a very frustrating experience, and probably a good segue into our next sort of overall topics about common challenges with parallel investigations. I'll turn that back to Erik.
Yeah, sure. Thanks, Len. So look, this doesn't cover all the challenges that one would see or that we've experienced when navigating these parallel investigations, but these are just some of the issues that we commonly see, or challenges that we commonly see. First off, distinct subject matters and focus, and what I mean by that is, even if a data breach is a good example, but there are certainly others. But even if the state AG and the FTC are investigating the same event, when they're using their own authority, they're going to come to their own conclusions and they're going to have their own focus. And so, it's very likely and common for the states versus the federal to focus on different aspects of an incident or of a practice. And so that can lead to a number of things. One is inconsistent requests for information. So your client or you're an entity that receives, you've got all these requests from a multi-state investigation. You have all these requests from the FTC or the Cfpb. Some overlap, which allows you to have sort of save some time and have some efficiencies, but a lot of them don't. And so you have to decide, and of course there are competing timelines related to that. And so you have to come up with a strategy on sort of how to provide when and when to do it, and sort of how to go about doing your internal investigation in order to obtain the information. And so that can be challenging. And, I will say sometimes the government, they don't always want to accept this. And maybe I was guilty of this as well when I was in the government, but they don't always want to accept that there only is a finite amount of time and resources, even for large companies. And so when you're dealing with multiple investigations at the same time, that becomes particularly challenging. And so figuring out ways as part of the negotiation with the attorneys for either the states or the federal side, if they're completely separate, where you can try to consolidate them and produce the information sort of that's similar on similar timelines is always incredibly helpful, which I think Len will talk a little bit more about. But there are also client considerations when you're dealing with this. Sometimes we haven't discussed this because I think that's an entirely different webinar. We only had an hour, but sometimes we're also talking about litigation. When like civil litigation, maybe there's a class action, or maybe there's one entity suing another that's just part of the event or the practice that's being investigated by the government. And litigation will also have a big impact on how you proceed. And that's something that the client is certainly going to care about and think about, but the government is not going to be worried about. And I got into this a little bit already, but I think it's just, it can be, the client can have strained resources as well. And that's something that, we always have to consider when we're trying to negotiate and dealing with these challenges with the parallel investigations, because look, if you're state AG, you don't want to hear that, well, I can't give this to you because, we're working with the FTC. That's not how it goes. You've got to figure out ways to satisfy everybody while also, protecting the interests of your client. And with that, I know we're getting short on time, so I'll turn it over to Len to talk about some of the considerations for investigations.
Thanks, Eric. So, as with anything in life, personalities and people matter. When Andrew Cuomo was the Attorney General for New York, he did not play well with others. Surprise some of you. He did not want to work side by side with the FTC in investigations. He did not want to work with other states in investigations. He wanted New York to go it alone. And the press releases, which is one of the principal outputs of an Attorney General's office, to just be Andrew Cuomo and the New York Attorney General. So that's something if you've got a case with an Attorney General like that, you're going to have to deal with it on parallel tracks at best, and sometimes conflicting tracks. So trying to understand the people at the federal agencies and in the Attorney General's office is important, because it really does matter. Trying to understand what's driving this. Is this really coming from the FTC? Is it coming from the Cfpb? Is it coming from the agency? Is it coming from a competitor? It can give you some insight into how to resolve it. If you can figure out the source of the irritation, it can help in putting that away. Do you want these states to essentially form a multi-state? Are you better off if you've got several AG investigations dealing with them as onesies and twosies as opposed to a multi-state? That depends on how you see this ending, and that's why in any of these investigations, one of the most important things to do up front is a vigorous early investigation and assessment, because unless you do that, you're wandering around in the dark. And another issue in trying to resolve these cases, and difference between the state and the federal, is a lot of the state attorney general's offices are funded by their settlements. So that's just going to be an issue. If you've got X dollars to spend, sometimes you're going to have to broker a deal between what goes to consumers and what goes to the AG's office for their fees. And Alex and I had two different cases where, one, we decided we're better off trying to settle them separately, and every time we think we've got the AG and the FTC pried apart, they come back together. I think the line attorneys would like to perhaps be apart, but the higher ups keep pushing them back together. So that's been a challenge. And then we had another case where someone in the Attorney General's office didn't want to stop investigating. We were prepared to settle, and the FTC was prepared to settle, but the lawyer at the state just, it's kind of like a dog with a bone, just not want to let that case go. And we finally had to essentially use the enough. Getting the AG to back off. And with that, I'll turn it over to Alex for some final thoughts on these issues.
Yeah, thank you. And we've covered a lot of this. At the end of the day, how this resolves, how these investigations resolve, is the most important thing, right? And so just a couple of considerations as to whether or not it's beneficial to seek a master settlement to get some sort of global peace. The risk benefit analysis is very fact specific. For example, if what's driving the investigations is a specific incident or event, oftentimes there are a lot of benefits, and it's also easier to get a global resolution than if they happen to be on broader, larger, more like policy issues relating to practices that cover a broad swath of your business. I typically tell clients that the most important thing is not so much if you get it all signed on the same day in the same document, but that the documents, the settlements are harmonized. The worst case scenario is that you end up in multiple settlements with different requirements that don't have consistent definitions, consistent like anything that relates to how to implement, when to implement, inconsistent deadlines, because that will become not just a nightmare in terms of on your company to incorporate what's required under the settlement, but it makes it much more difficult to be in compliance with all the settlements. And you don't want to be in a situation where you're setting up your company to fail. And so while there's a lot of benefits to seeking a global resolution and negotiating with the same people, it's very difficult, and it requires timing to fall into place. It requires the parties on the other side of the table to be ready to coordinate with different agencies, and that's not always easy to do given the priorities of the respective agency. And so with that, I'll just end it here, and thank you all for listening in today. If you have any questions, just reach out to us individually. I think you have our email addresses and the PowerPoint there.
Thank you all.
Thanks so much.